but the matter of tax rules and commissions are Majesty's body and
Good morning.
Good morning, my lady, my lords. My lady, this morning I'm going to address my response to HMRC's cross appeal.
Yes.
There are three main points which I want to address. Firstly, the wholly and exclusively point, why the tribunal was correct to hold that the person abroad had no income. A lot of the points which I was going to make have been covered in discussion with my learned friends. So I will try and be brief on that and just focus on the main points. As part of that, I will address why it wasn't sufficient to plead that the burden of proof was on the taxpayer in a tax appeal. And there's case law on that, which I'll take you to. Next, I want to address the transfer of assets abroad, and in particular, why we say it's not engaged in any event in this case. We slightly glossed over how the power to enjoy applied in this case if we have deemed income within the end user, and that we say is quite an important point. And then thirdly, I'll address the EU law issues. There are broadly 2 points there. One, is it engaged? And secondly, what are the consequences? And in terms of what are the consequences, I'll largely be referring to the two upper tribunal cases on the point. In relation to my Lord Justice Phillips mentioned the Fisher case. I think it didn't address the consequences of EU law for the transfer of assets abroad because the court there found that actually EU law wasn't engaged. So similar to what was found here, EU law wasn't engaged, and they didn't go on to address the implications for the transfer of assets abroad code. So that's why we say the upper tribunal decision on that is still relevant. So to deal firstly with the wholly and exclusively point. Starting point is just to look at what the first tier tribunal found. There are a few factual points which I'd just like to draw the court's attention to. So that's found in the core bundle.
This is on the assumption which you do not accept that we're within the transfer of assets regime at all.
Yes.
You're going to deal, but that's a respondent's notice point.
It's a point which we certainly raise in our respondent's notice. We say that there was no power to enjoy, even if HMRC are correct.
Yes.
And that's the point which
Yes.
I'll address.
Thank you.
So it's found on page 291 of the core bundle. Just to note, at paragraph 7, reference is made to the concession that the Rangers analysis applied. That, in effect, Mr. Hoey's emoluments were paid partly to himself and partly into the trust. And that we say is relevant because HMRC's case, so before that concession, was very much what Mr. Hoey's getting the benefit of is in reality his earnings, and focusing on the reality of the situation. This is his earning, this is his earnings. And we slightly moved away from that factual focus when we get to the wholly and exclusively point, but I do say it needs to be kept very firmly in mind. At paragraph 19, there the first tier tribunal makes reference to Mr. Hoey did not receive the full benefit of the absence of UK tax on his earnings because the fees chargeable by the various intermediaries were between 10% and 18% of his income, compared to the 1% which might be charged by a simple UK-based umbrella company. A substantial part of the hoped-for benefit of avoiding UK tax was therefore absorbed by the fees being charged by the promoters and facilitators of the scheme. Now, what that shows is that actually he was getting paid less under these arrangements than he would have been under a normal umbrella scheme arrangement in terms of what the cost was to the employer. Obviously, the difference being what he had in his pocket was a greater amount because of the tax saving. And that's how the thing turned a profit by convincing somebody to sign up for this, you'll get more money in your pocket, but actually we'll cream off more off the top.
Everybody benefits apart from the revenue.
Everybody benefits apart from the revenue, although, as it turns out,
Well intended to benefit.
So then the next bit, which we did go to, is paragraphs 147 and 148.
Give me the page,
Sorry, page 320. And this is just on the point on the motive defence. And effectively there, the first tier tribunal was deciding that motive defence didn't apply because even if Mr. Hoey didn't have tax avoidance motive, those who design or affect or provide advice in relation to the relevant transactions did, and that you had regard to those. The point being, that's a different issue, a different statutory question from the wholly and exclusively one. Which then brings us to the findings on paragraphs 162 to 169.
Yeah.
And I'd just like to make a few points on this. So it was agreed that the income was the profits. And then at 163, he talks about the evidence he was given and how that suggests the profit and loss account of Penfolds Hamilton consisted of the receipt of fees less the various other bits. At 165, he says, from the information I have, therefore, the profit and loss account of Penfolds Hamilton's consists of net fees received from DMS Cascade, less the salaries and payments into the trusts. There may have been a small amount of residual profit remaining in Penfolds Hamilton, but I have no evidence as to its existence or amount. Now, I think he's saying there may have been a profit there. He's absolutely not making a finding of fact that the employers in these schemes were operating with the purpose of not making any profits. On the contrary, he's saying they may have been making profits.
Yeah.
But I think it's important to address what the consequence of having no evidence is. So the burden of proof in a tax case to displace the assessment is on the taxpayer.
Yeah.
So HMRC have issued assessments. Those assessments are putting the profit of the person abroad as equal to the amount of the earnings. So that's a starting point which the tribunal must be going from, that the profits of the person abroad are equal to the earnings, but there has been no deduction for those earnings.
Yeah.
So he's got no evidence, so he must accept the basis of the assessment as being the maximum amount of earnings, shall we say. What he then goes on to ask is, well, are those earnings deductible? And he concludes that they were. And that's why you end up with a figure of nil, because you're starting from the figure which is in the assessment. And he's got no evidence either way to displace that. So that is the correct starting point. And so even though he's saying there may have been profits, he's got no evidence of it. And so he's applying the conventional approach which first-tier tribunals are expected to apply when a taxpayer hasn't displaced the burden of proof, which is you take the number which the revenue have come up with in their assessment. And that number is only adjusted by the one thing which he does have evidence on, which is the payment into the trust. And it's been accepted that the payment into the trust is emoluments. And of course, the whole point about the Rangers case is they say these amounts are salary. It doesn't matter if you pay your salary to yourself or you pay your salary to a trust. They're taxable in the same way. So salary paid to yourself, it's accepted that's deductible. Salary paid to someone else, he then goes on and actually analyses it because obviously the argument had been made, but he doesn't see any reason to apply a different approach. And that, we say, is perfectly rational.
Where was the burden in relation to deductibility?
I think the burden in relation to deductibility, I'd accept, would be with the taxpayer. But that burden is met wants its common ground that what's going into the trust is emoluments. And that's why he's referring to rangers, because both parties are agreeing that's the correct analysis. As to the burden of any dual purpose, we'd say we've met the burden of showing deductibility once we've shown that these are earnings.
Well, is that right? Because it's not just enough to show that they're earnings and that must be the purpose. It's got to be the only purpose.
Well, what we say is once we show their earnings, that's a prima facie case. That follows from McKinley. That once you show something as earnings, that's a prima facie case that actually it's deductible, and that meets the burden. And the burden then shifts to the revenue to say, actually, even though these are earnings, they're not deductible in this particular instance, or there is another purpose. It's not
Evidential burden.
Yes. It's not for, and this is the point I'm making, Skeleton, it's not for the taxpayer to prove a negative to say, well, and we can prove that there was no other purpose. It's for the revenue to come back and say, well, actually, there's evidence of this other purpose.
But one does have to take it in stages. I think you're recognizing and distinguishing between the legal burden and possible shifts in the evidential burden.
Yes, my lord.
And I think, I mean, you're emphasizing the McKinley.
Yes.
And you're relying for that purpose on what Lord Oliver said in the passage where he was distinguishing the facts of that case from the position of an employee.
Yes, he says, I think it's, it won't...
It's a passage I was putting...
Yeah, well, absolutely. It's a passage which we absolutely rely on because
yes.
my learned friend says, well, just because it's remuneration doesn't mean that it's always deductible.
Yeah.
But what Lord Oliver says is, well, it won't easily fail to be deductible if it is remuneration.
Yeah.
And so sort of simply showing that it's remuneration based on that approach, sort of in 99 cases out of 100, it will be deductible. It's only when actually you have something which perhaps isn't really remuneration, and the cases show it might be something like a distribution because actually it turns on not what you're doing for your employer, but the people who own the business.
Sorry, just one other point before I forget. I mean, you tell us, I think correctly, the starting point must be the actual assessments. We haven't in fact looked at those yet. I mean, I take it, well, my recollection is, I may be wrong, that yes, effectively, it's put on an alternative basis that the amounts which are said to be emoluments are also said to be the measure of the income abroad, which is being said to be taxable under the transfer of assets legislation. But I think perhaps we ought to look at the assessments just to see what it is that the taxpayer has to displace. At some point, I mean, if you can take us.
I'm not 100% sure they're in the bundle.
Okay.
Tab 18 of the core bundle. We can perhaps look at them now.
Yeah. Because to get the whole show on the road, so to speak, the revenue has to make an assessment, and it has to have a rational basis.
Yes. Well, we don't.
And
We
it
don't
has
have
to state the amount of tax which is said to be paid.
Yes.
As we know from the authorities we were looking at the other day. So sorry, tab 18. Was it?
Yeah.
Yeah.
So the opening, the second paragraph, in addition to income already taxed, this assessment brings into charge further sums that you received during the tax year. These related to an employment arrangement you entered into with Penfolds Limited, a company cited outside the UK. Although described as loans, I believe these sums relate to your professional work in the UK and are taxable income. In the assessment, I've estimated the additional taxable income based on the information currently available to me. The attached notice explains how to appeal. If you disagree with this assessment, you must appeal within 30 days of the date of the notice of assessment. And I think we did have evidence before the first tier tribunal about how the revenue went through this. They had various spreadsheets, and at various different stages, people identified the amount of loans.
I mean, that can't be right on any view, can it? Because the measure has to be the income of the offshore employer. That's not the loans. The loans came from the EPT.
Well, it's also clear from the HMRC statement of case, transfer of assets abroad was very much an alternative secondary ground of charge.
I mean, this seems to me just starts the whole show on the wrong basis. It's looking at the loans rather than the profits of the offshore employer.
Yes, it's not an assessment on the basis of transfer of assets abroad.
But I thought that was what we're talking about. I mean, where is the assessment on the TOAA?
Well, I think we have, what we have is, and my learned friends will correct me if I'm wrong, what we have is an assessment of for an amount of income, and then in terms of the statement of case, we have two alternative bases for saying this amount of income is chargeable. Because, bear in mind, my lord...
Yes, but that, sorry, I mean, it's the assessment has to assess the correct amount.
Is it 340? 340 is the start of and then at page 342, paragraph 3, and onwards.
And that's in the context of a self-assessment. You know, it's not actually one of the discovery assessments.
It's assessing a further amount of 101,000.
Yes. On an alternative basis, either it's income of which it said Mr. Hoey had power to enjoy, or it fell within section 727, which is the capital. Yes, I see, on the basis that the loans were capital sums. In other words, he had power to enjoy them on that basis.
Well, so certainly we haven't taken any point about the adequacy of the assessments in terms of transfer of assets abroad.
But that's where the discussion has to start, isn't it? So one wants to see where is an intelligible assessment on the basis of the transfer of assets abroad legislation.
Yes, although I think I understand the case being put. Not all of the income of the person abroad is attributable to Mr. Hoey.
Yeah.
And that follows from the transfer of assets abroad legislation. It's only income which arises as a result of his transfer. So you have multiple transfers into these employers in terms of multiple contracts. But it's only that income which is attributable to the transfer by Mr. Hoey, which can be subject to tax under transfer of assets abroad. The amount of that income identified by the revenue in the assessments is the figure which they say is the amount of the loan. So it must follow from that what the revenue are saying is the income of the person aboard attributable to Mr. Hoey's transfer of assets is the amount which he gets by way of loan.
There's a kind of missing step in that, and that the loan has to be also form part of the profits of the offshore employer, which it can't. It's a loan made by the APT.
Well, I'll get to that. I certainly say that's absolutely true. But in terms of the amount which HMRC are assessing under transfer of assets abroad, it's directly related to the amount of the loan, i.e. the amount...
Well, they're taking that as a measure of the,
yes.
of the income.
Yes.
But that's it. But the next question is, well, what is the income? And as we've been over this before, and the income has to be the profits of the offshore employer.
Yes.
I'm still going back to this point. How can the loans be treated as part of the income of the offshore employer?
Well, my point, my lord, they can't be, and that the First Tier Tribunal was absolutely correct to say that they weren't, and that actually the income was nil.
Well, that was a different point. That was the wholly and exclusively point. But we don't get there unless we have a proper assessment in the first place. I mean, that issue comes further down the road.
Yes, but my lord, it's not a point which we've taken, obviously, and I'm delighted to agree with you. But I think my point about referring to the level of the assessments is really to understand how the First Tier Tribunal was to go about doing this, that it has to come up with some sort of number for the profits, and going by the assessments is a perfectly rational approach. And whenever you accept that the assessments are based on the same number as the deduction, that's what leaves you with nil. And the absence of evidence is why you've got nil.
All they've done effectively is to assess the amount of the loans.
Yeah.
and then say on an alternative basis, those would be, those are fall within the transfer of assets provisions.
Yeah.
They haven't actually done any separate assessment of the transfer of assets.
No, they haven't.
ability.
No.
So it's very, very, very broad brush, high level. If it's not income tax, it's TOAA.
Yeah. But the first tier tribunal has to make a finding of fact based on something, and a rational starting point is the assessment. Is really all I'm saying.
But in a sense, that was what prompted my question in the first place. I mean, I agree that's a rational starting place. When you look at it, it's not at the moment at all clear to me how it was being formulated by the revenue. I mean, after all, they had to make an assessment in the first place, and it's their contention that the TOAA legislation was engaged.
Yes, and that comes to the pleadings, and it was very much the TOA legislation is engaged. The burden of proof is on you to say no.
So, all right, I made my point.
My Lord, the final point is that having assessed what Rangers is saying, the first tier tribunal says it's clear from these words that the payments made into the trust were nothing more or less than additional payments of salary. And those words, nothing more or less, do indicate that saying that there's nothing else to them. There's no other purpose. And then we have the conclusion that the income was nil.
So where are you now?
Sorry, paragraph 168 of the first tier tribunal on page 323. Apologies, my Lord. So in terms of those findings, we say it was both rational and correct. And in fact, there wasn't really any other sensible finding which the first tier tribunal could make in terms of the information in front of it.
Well, you don't even need to go that far.
No, we absolutely don't.
It was a finding that was open to the FTT
Yeah.
in the difficult circumstances
Yes.
of an opaquely pleaded case and evidence that wasn't as clearly directed at the issue as it perhaps might have been.
Absolutely, my lady. The only other point I'd make is that this is a type of fairly fundamental tax issue which the first tier tribunal is well versed with, and one would expect that, as here, they're able to deal with it shortly and concisely.
Well, we haven't got a reasons challenge.
No, but a part of at points, sort of in my friend's submission, it seemed to be suggested, but we ought to have had a much longer judgment. So from my own point of view, I much prefer something which is concise and to the point whenever we're dealing with something which ought to be fairly
amen to that.
Yes, absolutely, my lord. So in terms of
Well, Edwards and Bairstow is a very high threshold.
well, absolutely, that's what it's going to say. It needs to be shown to be irrational. When one looks at what Lord Oliver said in McKinley, I don't know. I don't think I need to take the court to it because we have looked at it already. But sort of the starting point is that payments of earnings do not easily fail to be deductible. So it's absolutely rational that if you've got earnings, you treat them as deductible.
And you've got a case here where one part of the earnings was treated as
Absolutely,
deductible,
yes.
and whatever the revenue's internal thinking about that is concerned, that was presented to the FTT.
Yes, absolutely. And more than that, the revenues case, let's remember, was that actually the reality of the other part is that it is earnings, and you're wrong to treat it as anything other than earnings, and that's why it's taxable. And of course, that was accepted.
Were the payments in ranges to the trust, were they deducted by the company?
That wasn't an issue in Rangers itself. What I can't remember is whether the time period was before or after the introduction of Schedule 24, which is the provision which was being looked at in Scots Atlantic, which would have prevented deduction until there was an earnings charge. But once it was established that there was an earnings charge, then presumably they would have been deductible at that point.
But if the revenue's right, then it wouldn't be, because the motive was tax avoidance.
Yes.
And even if it's subsequently determined that it's actually remuneration, it's still not deductible because you had an ulterior purpose.
Yes. Well, if the revenue's right, then
it's a double whammy
Yeah.
for the taxpayer.
yes. But what I would say is, if the revenue's right, there are problems anytime somebody does anything for tax reasons. So.
Well, that's why the submission is actually a very far-reaching one.
Very far.
Absolutely.
It looks as though the revenue are trying to establish a sort of high-level general proposition that when you're computing trading profits, any intention to attain a tax advantage must mean that wholly undeductible test has failed.
Absolutely, my lord. And it goes further than that. It doesn't have to be tax avoidance.
No?
I think I give the example of R&D credits in my skeleton argument. Now, that's somewhere where basically the legislation's been used to try and push people to actually spend money in a particular way. Tax has been used as an instrument of policy. If the revenue's right, that just completely doesn't work. And just to make good on the point that, and again, it's a paragraph which we looked at yesterday, so I won't take you to it, but paragraph 55 in the Scots Atlantic case, which makes clear that there is a choice in how to structure payments, which may be dictated by tax considerations. And given those two clear statements of the law, there's just no way in which the finding of the first-tier tribunal here can be irrational. And another point, which sort of just a more general point, but we do have sort of clear authority about the general relevance of fiscal motives in answering whether something's a trade or not. That was, I think, the Ingenious case repeated it, in which I think was my lord's.
Well, if you could give us some references, that'd be quite...
Well, it's the Ingenious Games Court of Appeal decision, 2021, Simon's tax case is 1791, paragraph 64.
Sorry, that's the Ingenious decision we handed down last August.
Yes.
Yeah. Which paragraph?
64.
Thank you.
Which just repeated a well-established point that
Yes.
fiscal motives don't mean that you don't have a trade. And it follows that a transaction entered into for fiscal motives can be a trading transaction.
Unless the thing is so disfigured by the tax that the Lupton principle applies. I mean, that's only reserved for very extreme cases.
Well, exactly. But it does seem to be quite difficult to align acceptance of that principle with the notion that if there's any sort of tax motive covering a payment, then that can't be for the purpose of the trade.
Well, it's the presumably of wholly and exclusively. It's the word exclusively which is relied upon.
Yes. Well, that's
And it said if you've got an ulterior purpose, then it's not exclusively.
yes. Well, I think it's the assumption that if you do something for tax reasons, that is an ulterior purpose, which has got nothing to do with your trade. Here, the whole trade was focused on getting people in, taking a part of what they were economically earning, and profiting from that. And the way in which you got them in was by offering them the tax benefit. That's why Mr. Hoey would work for 92 or 82% rather than 99%. And so the tax benefit was actually integral to the trade.
Yes, it was that what the tax avoidance purpose was.
The trading
Trade.
purpose, yeah.
Effectively,
Yeah.
because it was integral. Effectively, what the revenue is saying here, which is the whole thing, is a tax avoidance scheme.
Yes, but they're saying it's a tax avoidance scheme, therefore it can't be a trading purpose. But that doesn't fit with the facts. And so you can't just go, it's a tax avoidance scheme, therefore you don't get any deduction, which seems to be the general principle they're pushing.
But there were two limbs to their argument, which to some extent slightly overlapped and at times were slightly difficult to disentangle. They were also saying that it was relevant that there was no intention effectively to make a profit or no real profit. So none of it was really for the purposes of the employer. It was for purposes of lots of other people. And that, I think, was said to be linked to there being linked to it being a tax avoidance scheme but was slightly more than that, because at the end of the day, this employer is just a vehicle to make profits for other people.
Yes, the problem with that argument is it doesn't get off the ground on the facts, because the first tier tribunal found that there may have been profits. So the first tier tribunal did not make any sort of finding that there was no intention to make profits.
Or may have been a bit of profit, I think, is
Yeah.
what they really said.
Yes, but there's simply nothing to suggest that there was no intention to make profits.
And there's also the important point that in Ingenious we were looking at legislation which had it as an additional requirement that there had to be a view to profit.
Yes.
And we don't have that here. We're just dealing with the ordinary computation of the profits of a trade.
Absolutely, my lord. And one gets a sort of slightly absurd situation that if you trade with a view to profit and you make a penny, that's all fine. If you don't trade with a view to profit, then you've got a massive profit.
Because even if you make a huge loss, you can
Exactly.
still be trading. And
Yes.
even if you know you're almost very likely to make
I mean, lots of
Yes.
trades are designed to make losses in the early years. I mean, perfectly
Yeah.
legitimate thing. Or, you know, for example,
Yeah.
you're in the sort of areas where you have heavily front-loaded expenditure on research and development.
Yes, and I think that makes clear a point, which is that this is legislation which applies to virtually every trade and business in the country. It's intended to be workable. It's not intended to sort of have these overarching limitations on it, which mean that it becomes very difficult to operate, to calculate your profits sort of in the normal case.
Well, the breadth of what was argued seemed to be that if you can identify a benefit to any other person as being a purpose, even if a secondary purpose, it's not deductible. Seems to me to be of astonishing.
Yes, yes, my lord.
When you think about the complexity of the corporate arrangements that there will be, or indeed even of individual, personal arrangements.
Absolutely, my lord. And one thinks about sort of wholly owned companies and managing.
I mean, when my wife employs a nanny, she wants to benefit the children. Does that mean we can't deduct?
I don't think you can deduct it.
Anyway, or whatever. But if you're whatever the circumstances, you can think of all sorts of situations where you may be doing things for other people's benefit.
Yes,
in the course of your business.
Yes, and it may be that sort of Interfish, I think, being an example where they wanted to benefit the rugby team, that it wasn't sufficiently linked to the benefit of the business.
Yeah.
But it is a sort of. My friend made the point that it can be fact sensitive from time to time. So I wouldn't go so far as to say that trying to benefit somebody else will always allow you to have it deductible. But I think it does.
I'm particularly thinking about companies where you may be employing somebody who will whose work will benefit not just the company employed, but also other associated companies in the group.
Yes.
And that will be commonplace.
Yes, my lord. And
It will be an extraordinary suggestion if any benefit which is intended for subsidiaries is not deductible.
I completely agree, my lord. And that's why I say this is a provision which is supposed to operate in the commercial context, and it needs to be construed in that way. And that sort of situation, it would be commercially unworkable to say that actually, where you have a group of companies, you need to be approaching it on such a forensic way that you get artificial profits within the group. But we don't even need to go so far as to get into that, because we only need to show that it wasn't irrational to find that there was no profit here. And I think we easily meet that. My lady, my lords, that's all I propose to say on that point. I do want to address the pleading point briefly. And what we say is that, with respect, that this was an ambush. There's simply no reason, if HMRC were taking the point, that they didn't let the appellant, Mr. Hoey, know in advance so that he could prepare his case and answer it. And if he answered it to satisfaction of the revenue, then it might have been that you don't need to take up the first tier tribunal's time with hearing evidence on it. And frankly, the approach which was adopted of saying, well, the burden's on you and we're not going to identify where we're taking issues, was contrary to the overriding objective. And there's clear authority on that in a case called Fairford. Which is at tab 28, the authorities bundle. This was an upper tribunal decision following on from an application to strike out in a missing trader VAT fraud case. Now, the point there was that the burden of proof was on the revenue, and they had provided a lot of evidence, and the taxpayer wasn't particularly engaging, but simply saying, well, you need to prove all of your case. And the revenue initially, we're trying to strike it out on the basis that, well, there was going to be no answer to that. That strikeout application wasn't allowed, and on appeal it wasn't allowed. But what's relevant for these purposes is how the upper tribunal addressed the taxpayer's approach in the case. And this is dealt with at paragraph 44 under the heading Case Management on page 721. So at paragraph 44 we say at the start, although we have concluded that the appeal on the application of Rule 83C in the present case fails, the case raises an important issue about case management. And then halfway down paragraph 45 they make the point that to require a witness to attend in order to repeat uncontroversial matters in a witness statement is not consonant with the overriding objective. They're engaging with the overriding objective. Paragraph 46, in a letter of 20th September 2012, HMRC wrote to Bark & Co asking what issues they considered to be in dispute, what witnesses they wished to cross-examine, and 3, the time estimate for the length of the matter. On the 9th of October, Bark & Co replied, all issues remained in dispute, it required all witnesses to give evidence, and the time estimate was 25 days. Again, we do not consider such an approach to hearings in the FTT to be consonant with the parties' obligations under Rule 2 of the First Tier Tribunal Rules. That's the overriding objective. They then talk about a typical example of directions. At paragraph 48, in our view, the appellant should additionally be required to provide reasons if the answer to any of the second, third, and fourth of those questions is no. An appellant who advances a positive case will be required by virtue of other customary directions to set it out in witness statements or, if that is not practicable, in a letter, in response to or a letter or some other similar way. Accordingly, an appellant putting up a positive case must disclose his hand in advance. We see no reason why one merely putting HMRC to proof should be in a better position. If there is a real challenge to HMRC's evidence, it should be identified. If there is not, the evidence should be accepted. We see no reason why an appellant who does not advance a positive case should be entitled to require HMRC to produce witnesses for cross-examination when their evidence is not seriously disputed. Such a course is wasteful, not only of HMRC's resources, but also of the resources of the first-tier tribunal, since it increases the length of hearings and adds to the delay experienced by other tribunal users. In our view, the FTT should also direct that if an appellant raises no positive case, there is no evidence challenging the evidence of HMRC's witnesses, and does not identify the respects in which the statements of those of HMRC's witnesses who deal only with the questions set out at 47 above are disputed, then the evidence can be given and will be accepted by the tribunal in the form of a written statement under Rule 15 of the rules, and that cross-examination of that witness will not be permitted. In our view, this is both a practical and legitimate procedure for dealing with this type of issue. So, basically saying you can't do what happened here, just say, well, the burden of proof's on you. You need to identify the issues. And that we say is correct. That case was decided in, I think, 2014. So the principle was well established by the time we were dealing with the directions in this case. And it was absolutely plain from the directions, and there were a number of them, that the parties were being required to identify the issues, which is why we had so many, we had particular consolidated statement of case, then we had further particulars, and then there was a further point where we were required to identify any further arguments. So it was absolutely plain from the case management, all the issues should have been identified beforehand.
Does it make any difference? That was the case where the burden from the start lay on the revenue because it was an MTIC case.
Well, I think when they're talking about the revenue there, I think you switch that for the taxpayer here.
Yeah.
So I think it's just a point about when one's dealing in the tribunal with the party which has the burden of proof shouldn't just be faced with the burdens on you. The other side has to plead a positive case if that's what they're going to do. And so we say it applies equally to both sides, as one would expect. The other case which I'd briefly just like to take you to on this point is the Ulster Metals case. It's at tab 43 of the bundle. This is a decision of the Northern Ireland Court of Appeal. The reason I refer to it is it's applying what are reasonably well-established principles in the context of the tax tribunals. Just to note at paragraph 14, the upper tribunal found that effectively because the Taxpayers' Council hadn't raised the issue before the first tier tribunal, there was no unfairness. And the upper tribunal here have said, well, there may be a pleading point, but you're too likely to take it. That did not prevent, the Court of Appeal did not agree with that. At 1348, paragraph 34 at the bottom of the page.
Sorry, at 34. Oh, 1348 page number.
Yes, sorry. And paragraph 34, yes.
Yeah, thank you.
They cite Lord Justice Lewison in Prudential Assurance as to the importance of pleadings. It is for the parties subject to the control of the court to define the issues on which the court is invited to adjudicate. This function is the purpose of the statements of case. The setting out of a party's case in a statement of case enables the other party to know what points are an issue, what documents to disclose, what evidence to call, and how to prepare for trial. It is inimical to a fair hearing that a party should be exposed to the issues and arguments of which he has no fair should not be exposed to issues and arguments of which he has no fair warning. If a party wishes to raise a new point, he should do so by amending the statement of case. And further, at paragraph 24, he stated, parties to litigation are entitled to know where they stand and to tailor their expenditure and efforts in dealing with and only with what is known to be in dispute. That's not adding much to what we say in Fairford. But the point being that the court then applies those principles, said in that case the first tier tribunal had decided the case on an issue which hadn't been pleaded by the parties and said, well, that was unfair, and the issue had to go back. Notwithstanding that it wasn't raised by counsel before the first tier tribunal.
But pleadings are presumably governed by the tribunal rules.
Yes. Well, here the pleadings were governed by directions. We had quite extensive directions that the parties had to set out what their cases were and what their arguments were, and there were numerous pleadings sort of addressing different issues within the case.
But as to what is required to be in a pleading, is that a matter for the rules?
Yes, well, I think what Fairford says in terms of interpretation of the rules, and Rule 2 of the first tier tribunal rules being the overriding objective, that if you're going to advance a positive case, you need to do so.
But for example, in the civil procedure rules, there's express requirements that if you're going to allege knowledge or intention on somebody's part, you have to plead it. Is there an equivalent provision in the tribunal?
No.
But on the other hand, very specific directions were given by the tribunal in this particular case, including a specific direction to flag up any points which might otherwise take the other side by surprise.
Yes, absolutely, my lord.
So in a sense, I mean, what the underlying rules say doesn't matter particularly, given the very detailed directions that were given precisely to avoid this kind of problem.
Precisely, my lord. And we'd say, I think there was a direction to identify any further arguments you're taking. And
yes, I mean, they, if I remember rightly, they were the last substantive directions given before the trial.
Yes.
And although the rules only required, I think, the appellant to put in the statement of case, there had been earlier directions requiring the respondent to put in the statement of case, and then there was a reply to that.
Yes, I think it's actually the rules require the revenue to put in the statement of case. But yeah,
the other way around.
Yes.
Yeah.
But yes, and then there were rules about further arguments and further issues which popped up along the way, which is why we had quite a lot of pleading.
So on any view, there was quite a long period of preparation under the aegis of the FTT, which made appropriate directions, no doubt by consent, or at least following arguments if there was any disagreement about the directions, precisely with a view to achieving the objectives so clearly stated by Lord Justice Lewis and in the passage we've just taken us to in Prudential.
Yes, exactly, my lord.
So what's the case when it came to it? The revenue did not argue whether they conceded or not. They did not argue that the salary was not deductible, the express salary.
Yes, yes, my lord.
And it was, as I understood, it was also effectively common ground that the payments into the loan account were remuneration.
Yes.
The salary.
Yes.
So I'm not sure what the FTT was meant to have made of that.
Well, precisely. And I think that's why the FTT refers to ranges, because it's going, oh, this is what they've agreed.
Well, if at the hearing it's going to be said, well, the two different sorts of salary or remuneration should be treated differently, plainly there should have been an explanation of why that would arise in advance. The tribunal can understand what the issue was.
Well, quite. So those are my submissions on the income of the person abroad. The tribunal was perfectly correct to hold that it was nil, and in any event, the issue hadn't been properly pleaded. The next issue is the application of the transfer of assets abroad provisions. These are a quite complicated set of provisions which aren't, I think, in any view, drafted in the most straightforward of fashion. In terms of how they operate, if I can perhaps give an outline and then focus in on where I say there's an issue here. Now, this is approaching matters on the basis that I'm wrong, the first tier tribunal was wrong, and actually the income of the person abroad doesn't reflect a deduction for what went into the trust. So what you have is earnings going into the trust. So what goes into the trust is Mr. Hoey's earnings. But the taxable profits of the employer are actually a greater amount than what their real life profits are, if you put it that way. They have deemed profits equal to the amount of the earnings. It's important to note that these are deemed profits. They don't exist in the real world. There's no possibility of these profits being paid to anybody because they don't exist. The money which represented them has since become Mr. Hoey's earnings. So in terms of the transfer of assets abroad provisions, it's not enough simply to have an asset which is transferred to a person abroad. That will not engage the provisions, whether the motive defence applies or not.
You need to enjoy.
You need the power to enjoy. And what we say here is there is no power to enjoy that imaginary income and that power to enjoy must also be as a result of the transfer. So there must be a causal link between the power to enjoy and the transfer, causal link here between the employment contract being the asset which is created by entering into the agreement. And so it must be, HMRC must be able to show that this imaginary income, there is a power to enjoy it, and you have that power to enjoy it because of entering into the contract.
Well, is it imaginary? Isn't it the amounts that are in the EBT and ready to be paid out as loans?
No. Sorry, my lady, I'll let you continue.
Well, those are the deemed profits, but they're real sums of money.
No. Sorry, I'm interrupting
No, go
again.
on. You say why I'm wrong.
The amounts which are in the EBT
Yes.
are Mr. Hoey's income.
Yes.
So his income goes into the EBT. He's the person whose income has gone into the EBT. Incidentally, he's not a person abroad for the purposes of these provisions. No. The reason why it's said that the employers have profits is because their receipts don't get a deduction for Mr. Hoey's income. So that's not a real amount, because actually that amount has been paid away and has become Mr. Hoey's income. The only reason why you have taxable income is because you're denying deductibility to a receipt. So that's why I say it's imaginary.
Well, and that's in the hands of the employer. It's nothing to do with the EBT at this point.
Yes, absolutely.
We have to constantly remember what we're looking at is the income of the employer.
Absolutely, my lord. And that very much feeds into my point on power to enjoy.
Yes. Yeah.
Because
You say by definition he can't enjoy it because what he's taken is not taken into account in calculating that income.
yes, what he's taken and what he's enjoying is his own income. The deemed income of the employer, he's not enjoying. He couldn't enjoy because it doesn't exist in the real world. So there is no power to enjoy within the meaning of the provisions. And it's very, very important to identify what is the income we're looking at here.
Well, in a sense, it is in effect the consequence of the very strange position where, having said that the sums are the income of the employee, are the income of the employee, the revenue says, well, it can't be deducted.
Yes.
And that circularity, in a sense, comes back to bite them.
Yes.
Because that means that the income which they identify excludes the sums which are payable to the employee.
Absolutely, my lord. And it actually gives the provisions a coherent effect, because otherwise you've potentially got the employer being taxed once on his actual income, once on the deemed income. And I think the point came up yesterday in terms of double taxation. Well, they are actually two different sets of income. And we say the answer to that is that there's no power to enjoy. I will get back to the double taxation point, because if you're against me on the power to enjoy, then it seems to me that there is a double taxation issue. Perhaps if we can look at what is meant by a power to enjoy.
In the legislation.
Yes, in the legislation, which is page 455, starting at section 721. Say we're jumping over quite a few hurdles on the application of the legislation, but I think it's common ground as to where we get to. So looking at subsection 2 there, you see condition A is that the individual has power in the tax year to enjoy the income of the person abroad as a result of a relevant transfer, one or more associated operations, or a relevant transfer. Now, the first point I'd make there is in terms of the deemed income, there's no power to enjoy that as a result of the relevant transfer. The thing which he has power to enjoy as a result of the relevant transfer is his actual income, because he enters into an employment contract, he gets paid full consideration, and that's his earnings.
And why isn't that income as a result of an associated operation?
Well, associated operation is given a wide meaning, but it's difficult to see sort of what associated operation has been relied on.
The operation of the EBT.
Well, but the EBT doesn't have any of the. This is why it's so important to focus on the actual income which we're talking about.
This is the same point about the.
Yeah.
It's back to the income of the
employer.
employer.
Yeah.
That's what you have to
All the
have.
EBT has is the income of the employer. Absolutely, my lord.
And when you get to the power to enjoy section, that's all premised upon there being income of a person abroad, which you can enjoy in the specified ways.
That's the point I'm about to go to, my lord. Okay. So, just to note, 722(1) and 2 takes you to 723, which sets out the enjoyment conditions. So, condition A, this is on page 457, is that the income is in fact so dealt with by any person to inure for the benefit. Well, it doesn't exist, so it can't be in fact so dealt with. Condition B is that receipt or accrual of the income operates to increase the value to the individual of any assets the individual holds or assets held for the individual's benefit. Well, it's imaginary income, so it can't operate to increase the value of anything. But separately and importantly, the individual here, Mr. Hoey, has no interest in the employer. Condition C is that the individual receives or is entitled to receive at any time any benefit provided or to be provided out of the income or related money. Again, it can't be provided out of the income because it doesn't exist. There's no benefit to be provided.
I think the revenue only rely on A and D, don't they?
In that case, I'll jump forward to condition D. Condition D is that the individual may become entitled to beneficial enjoyment of the income if one or more powers are exercised. Well, it's impossible for him to become entitled to the beneficial income because it doesn't exist.
What about 7223?
A benefit to be provided out of the income or related money. Oh, sorry, 7223. Regard must be had to substantial result in effect of all relevant transactions. Yes, my lord. I think what that allows one to do is go. You have a look at sort of what's happening in the round. You don't focus in on any specific transaction. But I think what we're saying is having a look at it in the round. What's going into the EBT is the earnings of Mr. Hoey. That's the effective ranges. That's the agreed analysis. So that even looking at it in the round, that doesn't help because one's still looking at the income of the person abroad, and that's still what you need to be enjoying.
That must be the case, must it? Because the income only arises after discounting the payment of the trust. So in a sense, it's however substantially you look, however you try to look at it in the round, you do not have the income without discounting the payment to the trust.
Yes.
I mean, the person abroad is a trader, and you have no trading income until you've done the computation we were talking about earlier in the week.
Yes.
And it's only if you don't, as my law says, only if you then disallow that particular deduction that you have a positive figure.
Exactly, my lord.
And it's that income of which there has to be power to enjoy in one of the specified ways.
Exactly, my lord. It doesn't come up because, obviously, my old friend conceded the point, but sort of, I think an important point is, when does income arise to the two different people? An employee gets his income when he receives it or is entitled to receive it, which is sort of just looking at the cash, whereas a trading company, you're looking at striking a balance.
So that's why the priority argument was completely misconceived and has now been abandoned.
Quite, my lord.
Well, another way of putting it, which I think you do, is that although it goes back to a question I asked some time ago, which is, well, which do we look at this through the view through the eyes of taxation legislation? And the answer I was given unequivocally is yes, you do. But the fact still remains that you can't enjoy notional income.
Absolutely, my lord.
So, although for tax purposes there is an income here, there's nothing to enjoy.
No. Quite. And that's effectively the core of the submission.
And that fits in with the underlying purpose of the section, which after all is to deal with the paradigm case where somebody in this country parks real assets abroad with a view to enjoying the actual income derived from those assets offshore as if they'd been received here. I mean, that's what the section's all about.
Yes, it is, my lord. And sort of, we accept bracket applies, but I think it is very much a case on the margins of what the section's aimed at. And I think it does cause problems in other cases where, for example, you've got a trading company which has lots of employees, and how do you deal with their transfers? It's not entirely clear, and it's a long way from the paradigm example, as you say, of shifting investments offshore.
Yes, I mean, a good example reminded me, looking at some of the authorities, was actually the Magukian case, which I'd forgotten was the transfer of assets abroad case because it's always cited for what it says about Ramsey, but that was actually that was a sort of classic example of somebody trying to arrange things to get offshore income, get the benefit of it.
Well, yes,
and was caught by the section.
Yes. In those sorts of situations, it works very well, and it's actually relatively clear how it operates. It's when you try and shift it into sort of other commercial situations that it becomes a lot more difficult.
And there's no problem, because the whole premise upon which the income is deductible is that it's subject to tax.
Yes. It's earnings.
So tax hasn't actually been avoided in that sense anyway. So
no, I
maybe
think
the intention to do so.
Yeah, but well, yes, I think it was an argument which was rejected. My lord may remember in the Fisher case that sort of actually you need avoidance of income tax in order to engage the provisions, and said, well, no, you don't. But the provisions are there for the purpose of preventing the avoidance of income tax.
But that's the parliamentary purpose.
Yes.
Yeah, but that's why the legislation was enacted.
Yeah, but whatever the sort of hopes were to begin with, sort of we know that sort of actually income tax wasn't avoided by these arrangements because the earnings were fully subject to tax applying the ranges principle. So that is essentially my submission on transfer of assets abroad. What I would say is that if somehow you can say, well, the power to enjoy is pegged to what goes into the trust, then you're taxing a person by reference to what is in fact their income. And in that case, you are having a double charge because you're charging Mr. Hoey's income twice. And that, we say, engages section 7431. And my learned friend made submissions on the application of 7431 yesterday. I think possibly only in the context of the European law argument. We say it applies generally. And so that even if, sorry, would the court like me to go to section 7431 just to?
That'd just be helpful to remind ourselves.
Yeah.
And let's face it, that's dealing with a rather different point, saying no amount of income may be taken into account more than once in charging income tax under this chapter. So it's only dealing with charges under the transfer of assets abroad. And it's just saying you can't charge an amount more than once. And that rather ties into the situation I had in Majesty, where the revenue were making sort of assessments on lots of different beneficiaries in respect of the same income. And this shows that that can't be done. But that doesn't help with the kind of economic double taxation we're concerned with here, does it?
Well, I think the point is, if you can somehow get round the power to enjoy issue,
Yes.
the only way you can do that is by saying Mr. Hoey's ability to enjoy his own income is what engages the section.
Yeah.
So at that point, an amount of income is being taken into account in applying the charge. And what section 7431 says is, well, you can't do that.
I see.
And what it must disapply the charge under this chapter, because there's no provision which would disapply the charge for employment income purposes. And that's why we say,
I see. So this is, sorry, assuming against you everything we've been discussing so far.
yes,
Is as the revenue would like us to believe.
yes, my lord.
Yeah. So you then at that point you do have a potential double charge. I see.
Is this the section which the revenue was suggesting might be reworded? Yes.
Yes.
Mr. Mullen, is that a convenient moment to have a 5-minute break?
That's what I was just considering. Yes, it is, my lady.
Thank you very much for that. Just 5 minutes today. Thank you.
I think we just knocked.
Oh, sorry.
My
So
lady.
the EU answers.
Yes, my lady. I should say this is very much a fallback argument.
Yes.
If we're wrong in irrationality and we're wrong of the first year tribunal, we're wrong on the application of the transfer of assets abroad. There seem to be two issues. Firstly, is EU law engaged at all? And secondly, was any restriction justified and proportionate? As I am dealing with it as very much as a fallback, I'll try and deal with it relatively briefly.
Yeah.
In terms of whether EU law is engaged, the first point is that it's well established that where legislation or a measure is primarily directed at a particular freedom, then it is to be considered by reference to that freedom alone, and any impact on another freedom is going to be considered secondary. So that's the relevance of the legislation. So take an example. If we were looking at a TIPA here, so provision which is concerned with earnings from employment, then leave aside what the potential restriction would be, but then it would very much be clearly looking at employment, looking at workers, because you're taxing the income of workers from employment. And on that basis, the argument that, well, actually, you only can address this by reference to free movement of workers would obviously be right, because any impact on another freedom would be secondary, and that's absolutely clear from the case law of the Court of Justice. Now, we looked at the Fidium Finance case yesterday. That's what was being decided there. That was a case which was looking at the particular measures, and the paragraphs we were taking to were all talking about the measures in question. And so there they were saying the legislation, it's primarily concerned with freedom to provide services. Any impact on free movement of capital is secondary, therefore you can't rely on free movement of capital. And that's why they keep referring to the measures. I think if one looks at paragraph 34 of the FII case, that's extremely clearly spelt out. That's Authority 67. Sorry, no, it's not paragraph 34. It's 64, sorry, apologies.
So which page?
Page 2101. And it's paragraph 90. I apologise, my notes have
Paragraph 90.
gone rogue.
90.
Yeah.
90, yeah.
So you see it start, as regards the question of whether national legislation falls within the scope of one or other freedoms of movement, it is clear from well-established case law that the purpose of the legislation concerned must be taken into consideration.
So that's the starting point.
That's a starting point.
Yeah.
Now, in this particular case, we don't have an issue with that because it's accepted the transfer of assets abroad clearly is directed to movements of capital.
Or enterprises?
Yes. But I think if one looks at what is the primary freedom which would fall within the scope of transfer of assets abroad, the clue's in the name, it's about transfers of assets, which is generally movements of capital. The other point about movements of capital, which I think is made occasionally by the court, is that in terms of freedom to provide services, freedom of establishment, freedom of workers, you're normally talking about a person or an establishment or a business moving to another territory. Whereas with free movement of capital, you're normally seeing a person staying where they are, and it's their assets which are moving. And of course, this is a situation where Mr. Hoey has stayed in the UK the whole time. It's simply that his assets have moved from the UK to the Isle of Man and Gibraltar, being held in EBTs there. We don't take a great deal out of that, but just in terms of the way in which they generally operate and the way in which you generally see them operating, one wouldn't normally see free movement of workers being relied upon in a situation where a person stays in a country, remains resident in a country, and remains working in a country. That normally wouldn't engage the freedom at all.
You'd start with the legislation and you'd look at its purpose and
Yes.
you'd say, looks like capital.
Yes, so
Then you'd look at the facts, wouldn't you?
Yes.
And you'd look at what you were predominantly concerned with in relation to this particular fact matrix.
yes, so I think that's what we're going to come on to. But I think it's important to identify that there is that principle, because the principal authority being cited by the revenue for that, Fidium Finance, was actually, for the second principle, was actually dealing with that first one.
Right.
And the next issue is what happens when you, as we say, have a set of facts that are closely associated with one particular freedom. Now, normally, if that freedom's in point, the Court of Justice will just look at it in relation to it in parallel with any other freedom. But where an issue arises is if the particular freedom most closely associated with the facts is not applicable, but there is another freedom which is also engaged, which is applicable.
Not applicable because you've got a third country.
Yeah, it's not applicable because you've got a third country. I think there may have been other cases where it's arisen where it was not applicable because at the time in question, that freedom hadn't been brought into law. So I think free movement of capital came in after the other ones. And I think there's also the freedom to move and live within the EU, which isn't an economic freedom as such, where similar issues may have arisen. But I think the most obvious one is free movement of capital when you're looking at a third country situation, which is, of course, what we're concerned with here.
Yeah.
And so the question is, can you rely on free movement of capital, even though on the facts it's engaged in a secondary context? Now, I should say that we absolutely accept it. If on the facts you have got no movement of capital, then there's no question of relying on freedom. So we're assuming for these purposes that we can make out a movement of capital, and I'll address the court on that subsequently. Now, perhaps unsurprisingly, this is an issue which has come up before. This very same argument was made by the revenue in the FII litigation. And that was in the context of a wholly owned subsidiary based in a third country. Now, the case law is fairly clear that if you wholly own a company, you can influence what it's doing, and therefore that's not really an investment situation, that's an establishment situation. If, however, you only have a very small shareholding, you won't necessarily be able to influence what's going on. So that clearly falls within free movement of capital. So there's an overlap where you have a shareholding of the whole amount. Now, normally, when you're looking at the two, and both are in point, the revenue will, or the Court of Justice will look at it by reference to freedom of establishment because that's the freedom most closely associated with facts. But when you have the subsidiary in a third country, it can only, the only freedom in point, the only potential freedom in point is free movement of capital. And so this argument was made that, well, in the context of provisions which potentially engage both freedoms because, for example, it applies to shareholdings of 1% all the way up to 100%, can you rely on free movement of capital even though the factual situation is most closely related to freedom of establishment, which isn't in point? And that was the point which arose in the FII litigation. Now, it's useful to look at how the Court of Appeal dealt with it, because I think they set out, Court of Justice decisions can sometimes be a little bit opaque. They set out quite clearly sort of the nature of the arguments and sort of how they dealt with it. There was then the subsequent reference. So that's contained in the authorities bundle at tab 21. And I think this was an appeal from my Lord Justice Henderson.
It was, yes.
And the discussion of this particular issue starts on page 447.
447.
Yes, 447 of the bundle. And paragraph 44 of the judgment.
Bundle ends. Sorry, what page were you saying?
447.
That bundle ends at page 429. Maybe it's got not bundles, it's got muddled up. Yes, I'm sorry. Something's gone wrong in the bundle. I 447. I'm so sorry. Could you give me the page number again?
447 should be, it should have paragraph 44 at the top.
Yes.
Issue 2.
Yeah, I'm sorry. Yes, I've now found it.
So there were lots and lots of issues in this case.
That again, yeah.
But we're only going to focus on this particular one. And we can see at paragraph 46. The argument for the revenue is that Article 43 alone, so that's freedom of establishment, that is to say to the exclusion of Article 56,
Which was capital.
yes, applies in the following situations. The first is where the purpose of the legislation is directed solely at establishment, that is to say where shareholding is such as to enable the shareholder to exercise definite influence over the decisions of the company and to determine its activities. So that was the first principle which I mentioned. The second is where the practical effect of the legislation embraces exclusively or primarily such situations. The third is where the purpose of the legislation and its practical effect are not so limited and embrace movement of capital as well as establishment, but the factual situation under consideration by the ECJ is one of establishment. Now, that's the revenues argument here. The effect of that analysis is that there can have been no infringement of community law. There's no infringement of the community law prohibition on restriction of movement of capital under Article 56 by virtue of the Case 5 charge and dividends paid to the claimants from third country subsidiaries. The Case 5 charge is not directed exclusively or primarily to establishment or movement of capital, since it applies generally to income from foreign possessions. The factual situation before the court, however, does concern establishment, since the third country subsidiaries of the claimants are wholly owned by the claimants. That situation does not fall within the scope of Article 43, since that article is concerned only with dividends paid by subsidiaries in member states. The result is that on the revenues approach, neither Article 43 nor 56 can apply. The claimants, on the other hand, submit that if the tax legislation, like the Case 5 charge, is not aimed solely or primarily at establishment situations, Article 56 EC may be engaged in the case of a distribution by a third country subsidiary to its parent company in a member state, regardless of the size of the parent shareholding and the extent of its control and influence. Accordingly, on that approach, Article 56 EC may be relied upon even where, as in the present case, the third country subsidiaries are all wholly owned subsidiaries. The judge accepted the claimant's arguments. In our judgment, he was right to do so. On proper analysis, there is no authority for the revenues proposition that, in a case involving a third country subsidiary, Article 56 can have no application merely because the factual situation before the court is one in which the shareholding of the parent is such as to enable it to exercise definite influence of the decisions of its subsidiaries and to determine its activities. So that is the Court of Appeal rejecting the revenue argument. There is then discussion of sort of the various case law going into the issue, and in particular a case called Holbach, which was said to be very relevant. You then get to paragraph 69 on page 455, which is the conclusion. Holbach, Scattervet, and Glaxo clearly support the claimant's submission that Article 56 EC is capable of applying where the factual situation concerns distributions to a parent company resident in a member state from a wholly owned third country subsidiary. Article 56 EC will not apply if the purpose of the legislation or its practical effect exclusively or primarily concern establishment. Moreover, in cases where the purpose or practical effect of the legislation is not so restricted, but the factual situation before the court concerns an establishment situation solely involving companies resident in member states, there is no practical difference between the principles applicable under Article 43 and Article 56, so the court is likely, for practical reasons, only to consider the freedoms in the context of Article 43, unless the exemption under Article 57 is an issue. See, for example, paragraphs 33 and 35 of the Advocate General's opinion in this case. Where the case concerns a third country subsidiary, however, Article 43 is irrelevant. In the present case, the relevant tax is corporation tax charged under Case 5 of Schedule D. That head of charge is long-standing, it is not aimed at, and is not practically restricted to establishment situations. It applies to all streams of income from overseas. Accordingly, the judge was correct to hold that Article 56 EC is capable of being engaged in cases of distributions by third country subsidiaries to the claimants. So the revenue argument was being rejected. And that analysis, we say, is correct and is confirmed by the Court of Justice, because it appears, and
what about the argument that that allows the subsidiaries or the people to benefit from provisions when they're third country?
Well, I think the point which the Court of Justice makes in relation to that is, well, they're within the scope and intended scope of free movement of capital, so that's not an abuse of the right. That's the intended effect, because if you've got legislation which is properly considered to cover free movement of capital situations, then it's restricting that right, then it's of course correct and in accordance with the intent of the EU
And where does the CJEU say that?
It says that in the FII case, because this question, having been decided by the Court of Appeal, then I think goes back to the High Court, to my Lord Justice Henderson, and then there's a reference made And in terms of the questions on the reference, so this is tab 67, page 292.
209.
Yeah. That should be bundle 5, my lord.
Thank you.
So we see the questions on page 292.
Sorry, I'm not with you. Which?
So, sorry, tab 67.
67.
So this is FII number 3
This
in
is the 2012 reference.
Yes, that's right.
So that, right, that's the one that was made by the Court of, or rather by myself, in the light of the Court of Appeal judgment when it was remitted back.
Yes, my lord, I believe so.
And you say this question was referred, even though the Court of Appeal had decided.
Well,
or,
I'm not sure I completely understand why it was referred, because permission to appeal wasn't given on it, and the matter was remitted in relation to other issues. But
I can't remember either.
if we turn to, it appears to be the same question. If it wasn't referred, then obviously the Court of Appeal's decision is the end of the matter. But page 292 shows the questions which were referred. And question 4 appears to be the same issue. And we see the answer to question 4 at paragraph 88 on page 2101. And I think what the Court of Justice is saying is slightly easier to understand in light of having seen what was argued in the Court of Appeal. So paragraph 88, it sets out the question. Paragraph 91, it's setting out the principle that national legislation applying only to shareholdings is looked at in relation to capital, or you look at the purpose of the legislation. So paragraph 100 is when they're getting on to the particular issue. And it's within paragraph 100 that the Court of Justice both poses the point about misuse of the scheme and provides the answer. Such a risk does not exist. And then we get the answer at paragraph 104, which is the same as the Court of Appeal and my Lord Justice Henderson.
So if there's no risk of abuse, then you do look at the free movement of capital, notwithstanding it's a third country.
Yes. Well, I think what they say is there isn't a risk of abuse if the legislation in the member state in question
doesn't relate to conditions for access.
Yeah, which is, i.e.,
which is
the freedom of
the
establishment.
freedom of establishment. Yeah.
And so it's the the first test, the legislation test, which deals with and removes the risks.
Well, if the legislation is directed at both freedoms, but doesn't impact on access, and you've got a third country situation, and it doesn't actually interfere with access conditions in relation to the establishment freedom, then you would look at it as a capital freedom.
Well, I think if the legislation looks at both freedoms,
Yes.
then what's been said is, well, this is legislation which is concerned with free movement of capital. So there isn't a risk of inappropriate access to the market, because what you're not doing is dealing with a situation which is where the legislation is the rules, the measure, as they say, is concerned with freedom of establishment. and it's the nature of the national measure which governs whether it can relate to third countries or not.
I may have got this wrong, but I thought the general thrust of it is that where both freedoms are potentially engaged, you then have to look at the facts to see whether there's any risk of there being some improper profiting from the freedom which doesn't extend beyond member states. And if you can answer that question in the negative, then that's fine. You can apply.
Well, I don't think that's what they're saying in paragraph 100.
Is that right? Sorry, I got this wrong.
That's how I understood it, Mr. Mullen, because that sentence, such a risk does not exist in a situation such as this, is why it didn't matter.
Yeah, but it's the sentence after that. Such a risk does not exist in a situation such as that at issue in the main proceedings. The legislation of the member state in question does not relate to the conditions for access for a company from that member state to the market of a third country. So that's why I say the risk is addressed by the legislation. So you cannot rely on free movement of capital to attack legislation which is addressing freedom of establishment, for example, because that would risk undermining the rules for access.
But you have to go back to 93 and 94 to see what you have to do in a situation where both freedoms are potentially engaged. It's 94, in such circumstances, the court takes account of the facts of the case in order to determine whether the situation falls within the scope of one or other of those provisions.
Yeah, my lord, I think that's the point, that we wouldn't be in a position to say, well, we want to rely on free movement of capital, even though transfer of assets abroad is directed towards free movement of capital, if we can't actually show a movement of capital. So you have to look at the facts to see if actually a freedom's engaged. We absolutely accept that. So we say it's well established and clear that there is no rule that you exclude free movement of capital, even where the legislation is looking at free movement of capital, just by looking at, well, which freedom are the facts primarily related to. That was confirmed by the FII here, but if and to the extent that the revenue say, well, actually, FII, it's only looking at dividend cases, I think it's fairly clear from what the Court of Appeal said that they're looking at it in a more general context. And I would make the obvious point that there's no reason for treating dividend cases as sort of a special species of the exercise of treaty freedom. So the next point is, as I say, we have to show that as a matter of fact there was an exercise of the right to free movement of capital.
Yeah.
Now, reliance was placed on the Scottish case of Finucane, which in turn placed reliance on a very old CJU decision called, I think it was Luigi and Carboni. I think the continuing relevance and correctness of Luigi and Carboni must be open to question. I find no recent case in which the Court of Justice has applied that reasoning from that case. The most recent I could find was the Perche case, which involved gifts to charities, and the question of, well, is that an unlawful restriction of free movement of capital? And there's a reference in the Advocate General's decision to the Luigi and Carboni, and obviously that argument had been made, and they were saying, but what you need to do is look at the nomenclature, and the nomenclature talks about gifts, therefore gifts to movement of capital, and the Court of Justice doesn't actually deal with the point. So what we'd say is the reliance in Finucane on that decision to the exclusion of the nomenclature is wrong. But what I think makes the point even more clear is when you look at the actual content of Article 63, if we talk about free movement of capital, but actually there are two limbs to it. One is the free movement of capital, and the other one is the free movement of payments. So Article 63 is on page 524 of the legislation bundle.
So sorry, which?
Page 524.
524, thank you.
It is tab 13, so right very back.
Yes.
So 63.1 is a provision on free movement of capital, which is fairly familiar, but 63.2, within the framework of the provisions set out in this chapter, all restrictions on payments between member states and between member states and third countries shall be prohibited. Now, the argument was put, well, what goes into the trust, that's only a payment, that doesn't engage the freedom. Well, I think it's plain on its face it does. What's not immediately obvious is why this wasn't addressed in the Finucane case. But then we need to look at, in terms of the meaning of, well, the meaning of free movement of capital, the nomenclature, which is on the previous tab, tab 12, starting at page 512. And just starting at the very top, after the first paragraph, the capital movements listed in this nomenclature are taken to cover, then first bullet, all the operations necessary for the purposes of the capital movements, conclusion and performance of transactions and related transfers. So it's been deliberately classified very widely. And then just above the heading direct investments, we're told the nomenclature is not an exhaustive list for the notion of capital movements. Hence the heading number 8F, other capital movements miscellaneous. It should not therefore be interpreted as restricting the scope of the principle of full liberalisation of capital movements as referred to in Article 1 of the directive. And if we move to page 514, which talks about personal capital movements, which is clearly moving away from the idea of financial transactions. You've got loans, settlement of debts by immigrants in their previous country of residence, transfers during the period of stay of immigrant savings to their previous country of residence. Point being, it's about transfers overseas. Over the page at 515, physical import and export of financial assets, B, means of payment of every kind. Now, I think in Luigi and Carboni, what was happening was it was cash being brought into a country, and they were saying, well, that's not movement of capital, but it's difficult to reconcile that with this particular heading. And then we get other capital movements. We can see at D, things like authors' royalties are covered. And then E, which I think is very much in point here, transfer of monies for the provision of services. And the payment into a trust is a transfer of money for the provision of services. It clearly is a movement of capital.
Forgive me, the payment into the trust, though, is a payment by the employer into the trust.
It's a payment by the employer. Now, I think we have to remember the Rangers analysis here. It's a payment by the employer of Mr. Hoey's services, so it's a payment for his services. That's the reason why he's taxable on it, because it's his earnings. He's just said, pay it to that trust. So it is, on the analysis we're applying, a payment for services. That's why it's taxable as earnings. Now we say that movement of capital was restricted by having his earnings paid in this way. He's being subjected to, on this analysis, a double charge to tax. He's not only taxable on... So this is assuming I've lost and everything else.
How can a payment for services be a movement of capital?
My lord, because the nomenclature says so.
Where?
Sorry, that was the bit we were just looking at. Sorry.
13E.
Yes.
That's not what it says. Transfer of money is required for the provision of services. It's something different to paying someone for services.
Well, in order to obtain Mr. Hoey's services, the employer had to transfer money into...
If I buy goods from abroad, I pay them.
Yes.
But that's not transferring capital. That's paying...
Well, it's transferring money, my lord.
It's transferring money, but that's not a transfer of capital. I haven't got my capital here and transferring it abroad and retaining title to it. I have made a payment, and somewhere between here and abroad, title to that money passes. I haven't moved my capital. I paid somebody.
Yes, my lord, but I think what I'd submit is the very wide definition of capital movement, and it is a very wide definition of capital movement, and it's intended to encompass payments. And even if it weren't, going back to 63.2.
So you're going to have to show me where paying somebody for goods or services is moving capital, and that seems to be an extraordinary proposition.
Well, my lord, I'd say the other capital movements, the transfer of monies for payment of provision of services. But my lord,
I mean, this is all addressing the rights to receive monies, which is a different matter. And it seems to me you can argue that transferring the rights to receive the monies abroad can be regarded as a movement of capital. But it doesn't seem to me payment by the employer to an employee is a movement of capital.
well, it's certainly a payment, my lord.
Yes, because it's a payment, but you can't say every time you pay somebody, every time I go into a shop and hand over 50p for something, that I'm transferring capital.
My lord, if it's not within 63.1, I'd say it's within 63.2 because it's a payment. Because that's what 63.2 is about. It's about payments.
In the old days of exchange control, if one had bought goods abroad and paid for them, would that have been caught? It seems to me perhaps it might have been on putting using sterling to buy assets abroad was the kind of thing it would have been caught, and might therefore be the sort of transfer which the freedom of movement would be intended to facilitate.
Yes, my lord, and I think somewhere in the nomenclature there is a reference to exchange controls, and that was certainly one of the things which they relied on.
Miles from that here, because this is a payment by an employer overseas into a trust overseas. So there is no movement of monies overseas here.
Well, it's a payment by an employer of monies which have been earned by a UK resident national into a trust.
So it's moved by the intermediary.
So the overseas element is the UK resident.
Well, what's moved overseas is the fee has been paid by the end user to the intermediary, which goes to the employer. At that stage, it's got nothing to do with the employee.
Well, no, it's got everything to do with the employee because the employee is redirecting his earnings into the trust. I think we need to go back to first principles in terms of...
I'm sorry, I thought we all agreed this isn't a sham. The services are provided by the employer.
Yes.
And the employer receives those monies wherever they're paid.
Yeah.
And then the employer pays salary to its employee.
Yeah.
And that's the payment into the trust.
Yes. That's payment.
From what we know from Justice Hoffman is that what's been moved overseas, what's been transferred, is the right to charge for the employee services.
Well, and that I say would certainly...
That is the right that's been moved overseas, and that's why the legislation is engaged. And I would have thought, for my own part only, that you would have to show that that transfer is a movement of capital in order to get within the freedom here. Trying to squeeze it in by saying that the payment into the trust is movement of capital, I myself find difficult.
Well, if I can address that, 2 points. Firstly, having taken you to the opening words of the annex, that the capital movements are taken to cover all operations necessary for the purposes of the capital movements. That's capable of covering entering into the contract because that's an operation necessary for what follows. Secondly, the transfer of assets abroad provisions on sort of this scenario that I've lost and everything to date are engaged not by the transfer of assets. That's one requirement. The secondary requirement is the power to enjoy. So if there was no power to enjoy, no possibility of a charge. Now, on this scenario, and I appreciate we're sort of going back past sort of various points which, if I say are wrong, the power to enjoy is engaged by the payment into the trust. So in this scenario, the payment into the trust does trigger the transfer of assets abroad. And I think the upper tribunal were wrong in that because they focused on the transfer, as my lord is doing. But
it's the transfer that is the movement.
There are 2 movements which are necessary in order to trigger a charge, is our position. You can't get a charge just by entering into an employment contract. What you need is an employment contract and a power to enjoy. How we get to the power to enjoy is that we have a payment into the trust. That payment into the trust, we say, is a movement of capital because it's a payment for services. It's a movement of capital or it's a payment relying on 63.2. And if one wants to focus on the contract of employment, that's where I say the opening words of the nomenclature are relevant because it's an operation necessary for the movements which come later.
Well, it's not for me to make your case for you, but why isn't the right to receive monies analogous to the rights of someone to receive, an author to receive payments?
I'd say it's absolutely analogous, and that's why I did direct the court to D. But I just the more natural fit felt to be E, which is transfer of monies and return for services. So that is why we say the freedom is engaged.
Yep.
The next point is the restriction justified and proportionate?
Yep.
On that, we rely on the two upper tribunal decisions which have actually addressed this issue, which is the Fisher case and the upper tribunal in this case. So there's a bit of overlap in that Judge Raghavan, who was sitting in the upper tribunal in this case, was the first instance judge in Fisher, whose reasoning was largely accepted. So it's perhaps unsurprising that they reached the same.
Yes. So where do you want to start? With
If we start at Fisher, which is
Yep.
at tab 48, this was Judge Poole and Lady Justice Andrews. I should say the Court of Appeal, we were handed up the decision yesterday, has overturned parts of this decision and has overturned it on the EU law issue. That was because the movement here took place between the UK and Gibraltar. Gibraltar is treated as part of the UK, the same member state, for EU law purposes. Yeah. And what the court said was, well, you don't have an engagement of EU law rights there, notwithstanding that one of the parties was resident in Ireland.
Yeah.
Or was not a resident, was an Irish national, sorry. And so the court didn't go on to address the arguments on justification and proportionality, although I think it's probably fair to say that the main focus of the arguments anyway was on what the court did decide. So that has left the decision of the upper tribunal, as in this case and Fisher, as the two authoritative decisions on it. We say they're correct in their approach, and so that's why we adopt that.
Sorry, which tab was Fisher at first instance again?
At tab 48. This is Fisher in the upper tribunal.
Sorry, I mean the upper tribunal. Yeah.
So the analysis of whether the transfer of assets abroad code breaches the EU law starts at paragraph 149 on page 1483. Now, the first part of that analysis was whether EU law was engaged at all, which is the bit which has been overturned. And then you get the question of how the transfer of assets abroad code interacts and whether it's justified and proportional. Then that starts on paragraph 173 at page 1488. And 174, you see they're addressing justifications. At 175, the first two alleged justifications, that was balanced allocation of tax and fiscal cohesion, are not referred to in the grounds of appeal in any event are devoid of merit. They're not raised here. The FTT dismissed them in commendably succinct terms. And then they go on to address why they're not in point here. Then 176, Mr. Ewart realistically did not dwell on these arguments in his oral submissions. So far as the tax avoidance justification was concerned, he submitted that the type of considerations that arose in Cadbury Sweps relating to the fact that different member states may legitimately impose different levels of taxation do not arise in a case in which the situation was being treated as internal to one member state. So that was an argument which was quite specific to the facts. And then you see at 177, as the Court of Justice made it clear in Cadbury Sweps, particularly in paragraphs 61 to 69, quoted by the First Tier Tribunal, if the impugned transaction reflects economic reality despite the existence of tax motives, the objective pursued by freedom of establishment will have been achieved. Thus, the fact that a national of another member state wishes to avail himself of an advantageous fiscal regime, establishing their business somewhere that is treated as part of the UK, cannot be used as a justification for imposing penal charges upon them, which would not apply if they established a business elsewhere in the UK, for example, Wales. Now, that point is important because what the Court of Justice has said in Cadbury Sweps and on many other occasions is that a person is perfectly entitled to set up in another country in order to get the benefit of lower tax. Now, when we come to the transfer of assets abroad and the motive defence and the definition of tax avoidance, it's quite clear that you're not entitled to do that. That would be tax avoidance for the purposes of the motive defence. So if I move all my assets to, I don't know, Malta, because they have a lower tax regime, assuming they do, I couldn't rely on the motive defence in those circumstances. The reason I make that point is because it was suggested yesterday that, well, the motive defence, it deals with all the problems with EU law. And it clearly doesn't, because it's applying a very, very different test. And it's saying that something which the Court of Justice has gone out of its way to say you can do, motive defence is saying you can't do. And then at 179, we see the tax charge in the present case is unjustifiable because it does not target wholly artificial arrangements, however widely that concept is interpreted, but also targets transactions which could not possibly be described as constituting or involving artificial arrangements. This case involved a bona fide transfer at market value of an ongoing business from one company to another. As the First Tier Tribunal found, SJG, that was the Gibraltar company, is a genuine trading company which pays tax on its profits in accordance with the tax regime in force in Gibraltar. These measures seek to tax the fishers on the same profits which are generated from activities carried on in Gibraltar. Making someone pay tax on profits from a genuine business that have already been taxed in the territory in question cannot be characterised as preventing tax avoidance, as that concept is recognised in EU law. I'd say making someone pay tax on imaginary profits when they're also subject to tax on an equivalent amount, which is what the argument is here, equally cannot be justified. And then at 180, HMRC did not seek to argue that, were we to reach the view that the First Tier Tribunal was wrong to apply the conforming interpretation of the legislation that it did, in accordance with its obligation to interpret legislation consistently with EU law, we therefore dismiss HMRC's appeal in the case of Anne Fisher. And effectively what, and we'll see that the upper tribunal took a similar approach in this case, what they said was, you can apply a conforming interpretation by reference to the motive defence, so that if a person is exercising EU law rights, they can benefit from the motive defence unless what they've done is a wholly artificial arrangement. So basically, reading the motive defence and the reference to tax avoidance there to conform to what EU law requires. What that does mean is that if you're not exercising EU law rights, you're stuck with the normal meaning of the motive defence. We then rely on what the court said in this case on the point. Which is, sorry, the core bundle. I should say, there's one other case which I want to refer you to, a case called Lexel, which has recently been decided, which isn't in the bundle, but we'll hand out copies. but the reason why, and I'll take you to it after we've looked at the upper tribunal, the reason why I want to refer to it is because it was a case where there was something like a motive defence in terms of Swedish legislation, and actually it didn't save the legislation because of the way it operated. So, the core bundle tab 11, and it's page 242 starting at paragraph 304. So that's where the discussion starts. At paragraph 308, the court says, it appears to us that both parties accept that tax avoidance may in principle provide a justification and that the concept of tax avoidance has a particular meaning under European law, but they differ as to the extent of what is caught by the definition and whether Mr. Hoey's facts fall within such definition. There then follows a discussion of the ex-GmbH case, which my learned friend took you to yesterday. And I think there's no doubt that in terms of what the Court of Justice says in ex-GmbH is they're saying in Cadbury Schweppes, there was an approach to wholly artificial arrangements, but when one gets to free movement of capital, you need to take a sort of slightly wider picture given the nature of the freedom being exercised. We see at 311, the appellant's arguments appear simply to apply a formulation of ex-GmbH. To the extent that was what we were doing, we actually agree with what the court came up, or what the upper tribunal came up with here. And at 314, we consider that HMRC formulate the EU concept of wholly artificial arrangements too broadly. Their formulation misses out further constraints on the concept implicit in the court's definition. The artificial arrangements must seek to achieve the effect that the activity in the member state is taxed in the third country at a lower rate. In other words, it is not enough that there are artificial arrangements which happen to involve a third country which has lower tax rates. So the point being, they have to target, effectively, the artificial shifting of profits out of the UK into the third country.
That was just an example of how it might operate. It wasn't a requirement.
Well, I think it's fairly consistent in terms of when they talk about wholly artificial arrangements, that the thing which you're allowed, which is wholly artificial, is that it's profits within the UK which are being shifted out of the UK by some sort of artificial structure.
But one example of why you might do that is to achieve a lower tax rate in a different country.
Yes.
But that isn't a requirement. You may be achieving a tax advantage
In another way.
in another way.
Um,
And that's equally capable of
yes.
engaging the
Yes.
concept.
Yes, but I think the point about the important point is it's a transferring profits. It's something which should properly be taxable in the UK because of what's happening in the UK.
Yes, so there's a contract of employment. He's providing his services in the UK.
Yes.
And so the money should be in the UK and taxed in the UK.
And they are.
Well, they are now.
Yes, they are not. There might have been a point if the arrangements didn't work. But in terms of this argument about the double taxation, so having accepted that the monies are taxable in the UK, it seems to me that what the transfer of assets abroad are doing isn't targeting a wholly artificial arrangement which transfers profits out of the UK, because all of the profits, which are all of the earnings which should have been taxed in the UK, are subject to tax in the UK.
I see. So it's as a result of the concession that Rangers applies.
Yes. I don't think I need to go further and sort of explore whether there would be wholly artificial arrangements if Rangers didn't apply, because the argument which I'm answering here is one that actually you don't just get taxed on your earnings, you also get taxed on the deemed earnings of the employer. And it seems to me that in relation to that argument, it's absolutely plain that there's no scope for that justification to apply. At 317, we say, as the approach in ex-GmbH makes clear, artificiality may take different forms. What is objectionable is where someone seeks to escape a member state's taxation by being taxed in lower in a third country, but where that does not reflect the economic location of the activity takes place in the member state. So here, that would be the point about, well, if the earnings is the economic activity taking place in the member state and it's not being taxed there. Moreover, if the artificial arrangements concept was just about avoiding national taxes per se, it is difficult to see why the case law would need to refer to transfers to jurisdictions with low tax rates. Then in 319, they'd say it's wider than transfers of company profits, but not as wide as HMRC suggest. Then there's the question of proportionality. Before applying the above to the facts, there is a prior question as to whether the transfer of assets abroad legislation does target such artificiality. As is clear from Fisher Upper Tribunal, it does not. That is because the means by which one escapes liability, the motive defence, catches arrangements which are not artificial in the EU law sense. The restriction is not therefore justified and must be read in a conforming way so as to allow, where a person is within the scope of EU law, the motive defence to apply unless the person engaged in wholly artificial arrangements, as that term is understood in EU law. The relevance of looking at the facts is that if on the facts Mr. Hoey's case were even to fall within the EU definition of wholly artificial arrangements, then even if such a conforming interpretation were taken, it would not help him. Well, we'd say in terms of the double taxation argument, it very much would help him. I think that must be on the assumption that I think reading the motive defence in that way is sort of one part of the conforming interpretation which makes the legislation proportionate. And obviously, it addresses the situation where you don't have a wholly artificial situation. It doesn't address the penal aspects where you do have a wholly artificial situation, where the legislation has to be appropriate and directed to the particular mischief. And there, obviously, if it was said we had a wholly artificial situation and we didn't benefit from the rejigged motive defence, it would also be necessary to cut down the scope of the charge so that you didn't have that double charge. Because then, in that case, the transfer of assets abroad isn't applying proportionately because it's giving a double charge to address a single amount of earnings. And Lily, that we say is correct. And that addresses why, if on the basis that we have a transfer of assets abroad problem, we can rely on EU law as a defence to it. I did make reference to the Lexel case. I don't know if paper copies have been handed out. You should have paper copies of the decision.
Is that Swedish?
It is a Swedish case.
I did get it.
The facts are a little bit removed from where we are. The main point for looking at this case is just to see how it deals with motive defence, given the suggestion yesterday that having a motive defence basically cures any ills. What we say is you can have a conforming interpretation of motive defence, and that goes a long way to curing them, but just the motive defence in its current form isn't sufficient.
But you say even read with a conforming interpretation, it's not sufficient.
Well, read with a conforming interpretation in a situation where you get the benefit of the motive defence, then obviously that's great and that works. But where it said, well, these are wholly artificial arrangements and therefore you don't get the benefit of the motive defence, you then have to go on and ask, well, what is the consequence of the transfer of assets abroad applying? And I think, as we were discussing yesterday, it's well established. They apply in a penal way, and something which is penal is, in a sense, the very opposite of something which is proportionate. And so what we'd say is you have to cut down those penal consequences so that it applies in a proportionate way, which is focused on why the provisions themselves are justified in the first place. So an artificial transfer of profits out of the UK, then you would only expect to have a charge on the measure of those profits, not on a greater amount. So if it was to be said against me that, well, actually, the fact that he was attempting to engage in transfer of profits out of the UK, that means it was justified because that's wholly artificial. One then looks at, well, what's the consequence of that? Well, actually, he's chargeable on his earnings, and then you've apparently got another charge under the transfer of assets abroad. That's a double charge. Now, that is disproportionate. And I think this is the point which my own friend was making yesterday. So you need to cut down those disproportionate aspects of the charge as well. And the way in which one would do that, I perfectly accept what was being suggested by the Revenue yesterday in terms of Section 743, that would address it. But I think, as I dealt with earlier this morning, I don't think we even get there because
Yes.
the way 743 operates.
So where do you want us to go in Lexo?
Well, paragraph 31, you see the question referred being addressed. And paragraph 37, it explains what the exception is. This exception provides as well that interest expenses are not deductible if the main reasons for the debt having arisen is that the group of associated companies is to receive a substantial tax benefit. According to legislative preparatory works regarding the exception, it is for the company seeking the deduction to show that the debt was incurred mainly for tax reasons, that is to say, amounting to 75% or more. I don't myself entirely understand how we can say 75% of your reasons, but I take that to be sort of how one judges the meaning of mainly. So that is very similar to our motive defence, I'd suggest. And then we see the analysis on justification starting at 46. And at 52, they say, in the present case, it is apparent from the documents before the court that the exception is aimed at counteracting aggressive tax planning in the form of the deduction of interest expense and expressly aimed at any substantial tax benefit. In that situation, it is for the company requesting such a deduction to show that the debt has not arisen mainly for tax reasons, that is to say, amounting to 75% or more. The specific objective of this exception is not to counter purely artificial arrangements, and the application of the exception is not limited to such arrangements. As the tax agency acknowledged, in essence, at the hearing, the exception in question relates to debts resulting from civil law transactions, not really relating solely to fictitious arrangements. Consequently, according to the tax agency's assessment of the objectives of the transactions at issue, the exception may also cover transactions carried out on an arm's length basis, that's to say, in conditions analogous to those which would apply between companies which are independent of one another. In other words, the fictitious nature of the transactions at issue is not decisive for refusing the right to deduction, because the intention of the company concerned to take on a debt, mainly for tax reasons, is sufficient to justify refusal of the right of deduction. And they go on to say, however, the fact that a company wishes to make a deduction of interest payments in a cross-border situation in the absence of any artificial transfer cannot justify a measure which undermines the freedom of establishment. So it's a point which possibly is self-evident, but having a tax-related motive defence doesn't line up with the wholly artificial tax avoidance meaning in EU law. So, my lady, those are my submissions in relation to HMRC's cross-appeal, unless there are any further questions.
Thank you very much, Mr. Marlow. Thank you.
My lady.
Yes.
Perhaps I could start with the submissions made on Hoey exclusively and the imaginary profits. Our position is, my lady, as I have said several times before, I shall not seek to repeat my submissions. I'll just try and address the points made by my learned friend, that these are imaginary profits. And what we say, my lady, is that that's not the case. These profits are profits that are computed in respect of fee income that is received with deductions that are made, and we dispute that those deductions are properly made.
You dispute that they're wholly and exclusively, and therefore you can deduct, but the payment is made in real life, economically.
Absolutely, and it's made to him, my lady. And
Yes.
the point is that if he is able to benefit from something that happens above the line, as it were, before you arrive at the profits, and one is disputing the ability to deduct it above the line, it satisfies the requirement that he is able to benefit from the profits. Those are our submissions on that point. So the question is, are they wholly and exclusively deductible? Not whether he has a power to enjoy or not.
Well, you're asserting it, but why is it the case that something that is deducted before arriving at the profit means that you're enjoying the profit?
Because in the same way, we would say by analogy with the concept of the acquiescence into the arrangements that led to the redirection of earnings argument succeeding on the part of the revenue in Rangers. The fact is that these arrangements were arrangements that were entered into by the appellant, knowing that his income would be treated in this way, i.e., there would be a money that would be coming in. He would become an employee of an offshore entity. The offshore entity would be able to earn fees as a result of the work he provided to the end client as an employee of the entity. That fee income would then be paid out to him in two ways. So in the same way that it was part of his understanding, which brings home the Rangers analysis to him, we say that it is exactly the same analysis that applies to his ability to enjoy the fee income that was coming in, knowing that the amount that would be paid out to him, we say, was paid out with a particular purpose. The paying out to him happened, but we say the paying out to him cannot be a deduction in arriving at the profits. We accept that the income for these purposes is profits, but what we say is that in arriving at those profits, the appellant signed up to arrangements that meant that the amount that is paid out to him is not a deductible.
It seems to me that if you're right in this analysis, it doesn't matter whether it's deductible or not. It seems to be the whole argument on wholly and exclusively is irrelevant.
My lord, what we need to do is to consider the power to enjoy, because as we know, if I might take you to section 2.
Well, what's the answer to that? Why does wholly and exclusively matter if you're right? That the fact that he receives the income above the line, as you put it, is enough. In that case, the whole argument on wholly exclusively is for nothing.
No, my lord, if that is the impression I gave, that wasn't quite what I meant. What I meant was this, that in circumstances where there are, if I might just repeat one submission from my earlier, my orals, which is what we must remember is that these are arrangements that were structured in a way in order to ensure that there was a greater amount of take-home pay on the part of the appellant. As part of those arrangements, the employee entered into the employment contract with the employer and received those sums. Now, in ordinary circumstances where there isn't a tax avoidance purpose, where there isn't the intention to provide profits to be earned by other persons, not simply a question of benefit, my lord. I think you did ask said to my learned friend, it would be an extraordinary proposition if the mere benefit to other persons, such as subsidiaries, meant that it was tainted. And my answer to you, my lord, in submissions, and I repeat them now, is that the example that you gave was where the employment contract was entered into at the holding company level. So the holding company would be benefiting directly from the services provided by the person that it engaged, even though the effect of those services was to also benefit the trade of the underlying subsidiaries. So there is a distinction between the purpose there, which is for the holding company to be able to enhance its holdings, which are caused by the effect of the fact that the businesses of the underlying subsidiaries
Well, there are two
enhanced.
purposes: benefit the holding company and benefit the subsidiary.
We would say that it is a very, as I've said before, and my learned friend acknowledged, it's very fact sensitive. If the aim is, and this was the argument of Vodafone, Cellular and Shaw, my lord, if the removal of the owner's contract only benefited, was the purpose of it was only for the purpose of benefiting or for the purposes of the trade of the parent, then the deduction happened and it was available.
But this is going back to the question of deduction and wholly and exclusively. I think what I thought I'd asked you about is if you say the income can be taken into account because it's derived even before you calculate the profit,
Yes,
then why does it matter whether it's deducted or not?
if I could take you to the power to enjoy, because I think that is relevant to this part of the analysis. So just to remind us all that at page 454 of the legislation starts at 720, and the charge under this section, so subsection 1, you have that manual.
Forgive me, which page did you say?
We are at page 454.
Thank you.
So the charge under this section applies for the purpose of preventing avoiding of liability to income tax by individuals or ordinary residents by means of relevant transfers. We then say, subsection 2 says, income tax is charged on income treated as arising to an individual under 721, individuals with power to enjoy income as a result of relevant transactions. Then we look at 721, income is treated as arising to such an individual as is mentioned in 720 in a year for income tax purposes, conditions A and B are met. And the condition A is that the individual has the power in the tax year to enjoy the income of the person abroad. And so then one looks at what are the enjoyment conditions. And the enjoyment conditions include clearly A, that the income is in fact so dealt with. So if one reads income as profits, the profits are in fact so dealt with. Condition B is that the receipt or accrual of income operates to increase the value to the individual of an asset. Well, that doesn't apply in this scenario because there is shareholding or another asset that is enhanced. Condition C is that the individual receives or is entitled to receive at any time any benefit provided or to be provided out of the income or related money. And what we say is that here we have a situation where the loans are being provided to him. He knows they're going to be provided to him because that's the arrangement to which he signed up. He's entitled, therefore, to receive on this analysis. Those are paid out or to be paid out of income or related money. So the income is either the profits or the income is the related money, i.e., which is defined as money which is or will be available, that's subsection 4, for the purpose of providing the benefit as a result of the effect or successive effect on the income of any associated operations referred to in 721 sub 2. So we say condition C is met if you look at it in terms of the loans being made to the employee, because the income, i.e. the profits, are something in respect of which the individual is, sorry, let me put it in these terms. Condition C is that the individual receives or is entitled to receive at any time any benefit provided or to be provided out of the income or related. And we say that that is broad enough to cover this scenario.
I thought you were only relying on A and D.
We're not only relying on A and D, my lady.
I thought that is how you put it when you were making your submissions. But anyway, I stopped Mr. Mullen on that basis. So if there is a point in relation to C, he can make it later.
Absolutely.
Well, what you're basically saying is that if it's paid out of the receipts, then it's caught, and so it doesn't matter whether or not it's a profit or not.
But how can the receipts be within that definition of related money? Because that's all premised on there being income, isn't it? Money which is or will be available for the purpose of providing the benefits as a result of the effect or successive effects, A, on the income, and B, on any assets which directly or indirectly represent the income of the associated loss. So you have to first of all find the income, which means the income properly computed of the employer.
And that's what keeps bringing us back into.
But you're trying to go back to the submission that a mere trading receipt is income for these purposes.
My lord, no, I'm not. What I'm trying to say here is that it's a question of whether or not there's an entitlement to receive is a benefit out of income, i.e. the profits for these purposes.
Yes.
But in circumstances when the arrangements themselves are postulated in a deduction being made for the very thing that the individual is capable of enjoying. And it is that, we say, brings it within the scope of the power to enjoy under condition C. Under condition D, we say that the individual may become entitled to the beneficial enjoyment of income if one or more powers are exercised or successively exercised. And in that scenario, the beneficial enjoyment of the income being, again, the profits, but in circumstances where we say that the profits include the amount that he is able to enjoy by way of loan because of these arrangements. This is not a far-reaching proposition. proposition as is concerned. What we're looking at very specifically are a structured set of arrangements where the aim was to provide the benefit, as it were, at a point before the profits are to be computed. But that forms such an integral part of these arrangements, we say, that you need to question whether or not it is a true deduction.
But what, I don't understand why.
Because we say it is tainted by the tax avoidance purpose. And the tax avoidance purpose is not just the purpose of achieving a tax saving for the employee, but also ensuring that profits are earned elsewhere.
Well, that means we're not just looking at wholly and exclusively then. We've got some other test of tainted as to whether it should be deducted.
My lord, but wholly and exclusively does include the question of tainted. The tainting is there any other purpose? And that any other purpose, we say, includes a purpose of providing a tax benefit to an employee where there is no evidence that benefits the trade.
Sorry, it doesn't matter then.
Forgive me, my lord.
Well, no, that goes back to my lord's point. Why does it matter if you can tax it anyway?
Well, because what we would say, my lady, is this, that in ordinary circumstances, when it's just a straightforward trade, when a certain amount is being paid out, and there is no reason to doubt the deductibility of a payment being made out, then the profits will be the income less the permitted deductions. And that will be the ordinary scenario. However, in circumstances where you have structured avoidance schemes that seek to make the deduction in order to arrive at the profits, where the amount that is deducted is intended to be enjoyed by the employee, and at a tax saving. So we say that is the tainting there. And where the profits are arising from these arrangements are not enjoyed by the employer, but by other persons. Those are the circumstances in which we say the permissibility of the deduction is doubtful and ought not, therefore, to be given, because there are more than simply, for the purposes of the trade, reasons for making that deduction.
And the consequence is that the profits include that sum.
Yes, for these purposes, yes. But this is not a far-reaching proposition. I am conscious of the time. It is just over 1 o'clock.
Yeah.
I shouldn't be very long after lunch, but I think I may be about half an hour.
Yeah. Very good. If that's a convenient moment, thank you very much. We will rise for the shorter journey.